The more people learn about it, the more exciting they would regard this as a tool for their future. I mean, it's far more exciting to plan your security and your safety and to know that you've covered those things that may not all happen, but there's a good chance in this world with medical technology and whatnot being around, it's as important to plan for these plan B discussions and to know that you have this wonderful plan in place that gives you assurance that the things that are most important to you while alive and when dead are taken care of.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. We're picking up this week with a topic that we've been covering over the last, several episodes, and that's to introduce you to the fundamentals of wills and trusts and phrases that are thrown around a lot in estate planning, which many people don't fully understand and are all too often misrepresented online. I mean, many people pick up things that people say, who some are lawyers even, but even worse, many are not even lawyers, and they're dispensing advice which is just bad advice and based on bad information. So we want to cover these basics in a way that's not theoretical, that's very practical for you. I mean, you are making decisions about the balance of your life, about your family, and you want the greatest confidence you can have that you're getting good information. Well, one of the advantages of the estate planning group at Cordell and Cordell is that that's all that group focuses on. And our leader, John Sauter, I mean, he is in fact the person who leads much of what goes on in that department. So it's all he does. It's all he has done, to my knowledge. John, you've always practiced in the area of estate planning.
That's right. Ever since I started being a lawyer.
Yeah. So anyway, it's appropriate that I have John join us in this discussion. Oh, by the way, those of you who have questions or comments, be sure and submit those to us. I mean, we're happy to address things you're concerned about. We want to know what you're thinking. So drop those in the comments section and we'll follow up. And we want to go through several topics. We've covered a lot already. We've explained to you about wills. We've talked to kind of the mechanics of how trusts work. So now we want to move into talking about how is it that trusts work on the ground in real time, meaning once you've hired a lawyer, you've had a trust created, you've identified your trustee, you've identified your beneficiaries, and so you're wondering, well, what does this look like on a daily basis? What do you do for the balance of your life as presumably the trustee? And we want to talk that through and let you know, is that a lot of effort? Does it require additional money to keep a trust in place? Is it a big headache? So I think we can allay many of these concerns in talking about that topic, and then we want to move on to a couple things that are related. But let's start, John, by addressing that question. So how do trusts actually work on an ongoing basis? And we'll assume this is while the trustee is still alive, the trustee and the founder of the trust, the trustor, is still alive.
Yeah, that's right. And when we discussed this before, we talked about how the trust has those three main characters, right, that you just talked about. The owner or creator, sometimes referred to as the settlor, the trustee, and the beneficiary. And I think the thing to know about trusts is they're different than a lot of the other documents we're creating in that they become effective immediately upon you signing them. And so when you create a trust, you've essentially created an entity that springs to life the moment that you sign the document. And that's why sometimes a big question we get about is says about $10 has been added to the bank account. Do I really need to deposit that $10 into an account? But no, that's just meant to say that this thing is funded and it's active, right? And so that's different in the will in that the will doesn't become active until a court says it so. But it being active immediately is important to understand because it could handle your assets if something were to happen to you while you're alive, right?
Which is one of the wonderful features of a trust is that it's providing these benefits while you're alive.
That's right. And when you fund your trust, you're going to have two choices for each asset you have. Do you title it in the name of the trust now, or do you make it so it only goes into the trust upon your passing? And the reasoning behind that, when I talk to people about it, I'll say, if it's something you're going to actively manage, it might be easier to keep it in your own name. Okay. You don't have to constantly give people information about the trust, explain that you're the owner and what your authority is, so like a checking account. But if it's something you're not going to manage actively, a property in another state, an investment you plan on keeping and holding, putting it in the trust puts that plan in place right away.
And, that is especially important for older people who, the probability of their becoming in a very short order incompetent due to some event, such as a heart attack or stroke or whatever. Those probabilities are much greater when you're older than younger. When you're younger, you can still have auto accidents and things. So some of our younger clients still, they want to go ahead and put things in the trust because they kind of like having everything in place so that if something happens to them, the person that they've named as their successor trustee is immediately in a position to take over.
That's a great point.
Without missing a beat. But as you point out, depending on the asset, it could be a few more steps or one additional step, really, whenever you're interacting with third parties and something's in the name of the trust. You don't have to be a lawyer to appreciate that if it says the trust owns it, then it's fair for a lender or somebody with whom you're doing business to say, well, gee, can you give me something to satisfy me that you're the person who's in charge of the trust? And that's all that it is. If there are documents you'll have at hand that you will be familiar with because you regularly use them, if this is the way you're operating with those types of assets. But as you say, John, it's no big deal if you decide to leave it out. You want to be sure, though, that if you're going to leave those assets outside your trust, you're very vulnerable to these incidents that I described without something to cover it. And that something is a durable power of attorney, both one for assets and property and business, as well as one for healthcare. I mean, that first one, the one relating to your business and material affairs, I'll call it, that's got to be in place if you're keeping assets outside your trust. You want to talk a little more about that, John?
Yeah, that financial, or sometimes called a general durable power of attorney, that is going to be your backup plan for assets you don't put in the trust right away. But when you're thinking about when you put it in the trust now, if you do need to prove your ownership, we're going to give you a document called a trust certification. And people will ask, like you said, they have the right to ask, what is in this trust? Who's got the authority? They don't need to know all of your personal business. They don't need to know everything the trust says. There's certain things like your social security number, your address, things they need to open up a bank account, make changes to your account. That's all going to be in that 2-page document we give you, which is a little easier to carry around than carrying around that whole trust. And so
that's a good point. So that document doesn't disclose the details of the terms of your trust or the other assets that are in it.
It doesn't talk about who the beneficiaries are, specifically doesn't talk about the assets, just lets the person that has questions know you have the authority to act, and that's all they really need to know.
Yeah. And John, talk about then for those assets, those people who, for whatever reason, decide to keep some assets outside the trust. And I would say the majority of our clients keep some of their assets outside the trust. I know that the listener is thinking, if they're not familiar with this topic at all, they're thinking, well, gee, how does this make its way into the trust? Doesn't that mean it goes through probate? Talk about that.
Yeah, the real controller in relation to your assets is the title. And when we're talking about this, we're always talking about your property, like a house has a deed, bank account has a statement and a signature card, vehicle has a vehicle title. And what it says on that title is what determines what happens with that property. You only end up in court when there's no direction given on what should happen if you can't act. And so what we're going to do is, if we're not going to put it in the trust now, we're going to give some direction on that document about where it's going to go if something happens. So with a bank account, that'll be a POD, or a payable on death. Vehicle, they're going to call that a transfer on death. Most stocks, it's called the same. Or, the language most people are probably familiar with is a beneficiary designation. Anytime you sign up for insurance or 401k, they ask you to put that. And in most instances, you're going to name the trust. So you make sure that asset follows the directions you're leaving.
Yeah, and so we could say maybe the bad news is that yes, it does mean that anything that is not in your trust would go through probate. But the good news is that it's a very streamlined probate. I mean, if that's the only assets we're talking about, then you have a will. There's this pour over will, which, as it simply says, whatever assets are in my estate, dump them into this trust, and so that's a pretty streamlined process.
Yeah.
So yeah, on the one hand, you do go through probate, but the good news is that your plan, the plan that you really care about for what, if well planned, will be decades of the lives of your loved ones. I mean, if your trust stays in place to help benefit them over decades, then yeah, it's a little bit of hassle, but that those assets go through probate in order to end up in your trust. But it does get done. It gets done pretty inexpensively and efficiently, if by terms of probate, I'll say. But anyway, it gets where it belongs. It doesn't disrupt your plan. Your grand plan is undisturbed by that, except for a little delay and a little bit of expense. But then what you have designed for the benefit of your loved one stays in place for however long you've chosen to have it in place.
Yeah, you're going to make mistakes. You'll buy a new car. That's probably the biggest one, and forget to title it in the name of the trust. Or you'll open up a new account. I had a client a while back that had his financial advisor call him and say, this interest rates just jumped up. Let's put a chunk of money in this money market account. Well, it all happened so quickly, nobody thought about the titling. And then we have this one asset that he happened to pass a week after that account was created, and we had to pass it through probate. Like you said, easier process, only had the one asset, didn't cause a lot of grief for anybody. But getting back to what happens while you're alive and your property is in a trust, the only real issue is just proving that ownership. And I think people get concerned, I don't want to put my property in my trust. I don't want this to be a pain. When, as far as for tax purposes go, nothing's changed when you put your property in a revocable trust while you're alive. It's still reported on your taxes the same way as it would have been with outside of the trust. You use your Social Security number as the tax ID. And so there isn't a big burden, but there is a big benefit, right? And that is, if that property's in the trust and something happens to you, what do? We just look at the terms of the trust to determine who can act next, right? That successor, whether it's your spouse, a sibling, a child, they can step right into that role. They don't have to do anything additional, and they're just right in your shoes right away.
Yeah, and one thing that we'll call attention to, and that's the reason that when you're doing this, you need to have a lawyer who understands not only the estate planning piece, but to some extent at least the tax piece. And as you point out, this isn't a taxable event when you transfer stuff into this type of trust, unlike an irrevocable trust, for example, that creates a separate entity that can have implications for you're having to file a tax return for that, for the rate at which assets are taxed. But not true with what we're talking about here. We're talking about a revocable trust, so the IRS isn't interested in it from a tax standpoint. However, unless the laws change, John, sometimes people would decide for strategic reasons to not put certain things in their trust because at death they got some benefits if they had it outside the trust than if they had it in. And for those assets, that's no problem. You still, you want the same plan you had, but you do it a little different way. In those cases, as to those assets, they might keep them out of the trust. They have the pour over will we were just talking about. So they follow that pathway and still end up exactly where you want them to end up. But there are some assets that, and depending on how tax laws change in the future, you might decide for those reasons to keep out. Regarding the stepped up basis for appreciation in real estate, unless the laws change, sometimes you didn't get that step up when you transfer to the irrevocable trust. Do you know that?
Yeah, the state of Florida is a big one for that. They have that homestead exemption that's very generous. It's up to $5 million on your primary residence, which is a lot larger than you would get on the federal level. And so they have special rules about not transferring to trusts. But you're right, it's a small sliver of assets that you really got to worry about that. And like you said, if you've gone to an estate planning attorney, they'll know these for your state and your jurisdiction.
Yeah, that's the reason we try to have attorneys who are living and working in the jurisdictions in which they're practicing as estate planning lawyers, and another advantage we have as a group is that we have lawyers who focus on the tax issues, and they'll sometimes consult with our other lawyers, and that sort of large team approach, which Cordell and Cordell has, adds benefits that it's hard to get with a single guy or a couple of guys or gals in a small office, which is what estate planning, for the most part, is in the legal field.
That's where I came from, and that's why I came here. One of the biggest advantages you can give to your client is your breadth of experience. The more you've seen, the more you've experienced, the better you can advise somebody because you have a better idea of what could happen. And having all these people in all these different states, and we all talk and meet regularly to discuss these things, you just know that if you ask me a question and I don't know it, I can easily turn to my resources here, and we're going to have the answer.
Yeah, so we do like that team approach, and we do think it gives us an advantage in practice. I want to move to another question here that relates to kind of a myth that's commonly out there, and that's that only rich people have trusts, that it's something for the very rich. And I mean, obviously, this isn't true. I mean, high net worth families, certainly, there are certain types of trusts that you do see with people who are wealthy because they're designed to deal with high tax rates and the sort of problems that somebody has with the amount of assets they're transferring at death. And with the exemptions being as high as they are, you're looking at people that are going to be, almost at $30 million in excess of that, in terms of raising concerns about estate and gift tax. But that could change over time. But people make the mistake of thinking that special type of trust, that those irrevocable tax-oriented trusts are the same thing as the others. And you might dispel or explain that misunderstanding, John.
Yeah, trusts are not just for the wealthy. And that's the biggest misconception we come up against when we're talking to new clients. I understand where it comes from. Trusts have been more adopted widely recently. You go back 40, 50 years, you didn't run into them very often. And they were more something that wealthy folks used, right? And they were dodging taxes with them and doing different things to make sure that they could preserve wealth over generations.
Those offshore trusts, the Cayman Islands, I wouldn't mind having some clients where I'd have a good reason, a tax-deductible reason to get on a plane and fly to Cayman Islands, John.
We were glad to help those folks, right? And to be honest, they've moved on from trust. They're creating things like family partnerships. There's all kinds of new products that help them achieve
Bitcoin.
that help them achieve what they used to through a trust. But the reasons they used them before, sometimes I explain to people, if you remember radar detectors, right? From when we were younger, he had that fuzz buster. Every time they'd create a new radar, we'd get a new fuzz buster. And that's what it's been like with the wealthy and estate planning. Trusts were their original vehicle, but a lot of the things that they did with trusts, the IRS has figured out, okay, we'll put new rules in place, like the generation skipping tax. And so a basic trust hasn't been as good of a investment for the wealthy as it used to be. Still a great investment, right? Still a lot you can do with it. But for the individual, trusts have come around to be a great planning tool, mostly because of their flexibility. The ability to say, this is what I want to happen, okay? But if it doesn't go this way, this is my backup plan. And this is my backup plan to the backup plan.
Yeah. And what many people those of us who practice estate planning law, very few made that decision because they are interested in a branch of tax law, meaning that they really wanted to do tax law, and I'm going to do tax law as it pertains to estate planning. I mean, that's okay, and there's a place for that. But once Congress had elevated the exemption, the estate and gift tax exemption, to the level that it has, to a great extent, it's taken that sort of abstruse tax planning off the table. And now, those of us who do estate planning for the vast majority of our clients, uh, our focus throughout those conversations is really on, what are the things that you want to accomplish with your security, with the quality of life you have for the balance of your life, and let's allow for the exigencies that notoriously pop up between those years of 60 and 90 or 100. In those years, lots of stuff can happen. So it's all the more pressing to plan for those. That's the sort of exciting focus and discussion that can excite me as an estate planning lawyer. And I know you and others I've talked to feel the same way. And then to talk about, well, gee, what about after you're gone? How can you best benefit the people you care most about? That conversation now can largely take place for the substantial majority of our clients, well in excess of 90%, can take place without spending much, if any, time talking about tax implications.
Yeah, it's an easy answer because it's the best tool for anybody that wants to do estate planning. Not everybody's going to end up using it, like you said, but it doesn't matter what you have. It don't have to reach to a certain level for a trust to work for you. Not just the ability to have that flexibility, but there's two other big things that having a trust in your plan can benefit you. And one is control, right? You will control whatever property is in that trust, even when you're not here anymore, based upon the instructions you left, right? The second is protection. And this is something we talked a little bit about in the last time we covered this topic. When that revocable trust that's easy to manage during your life, once you're gone, it becomes irrevocable. And because it becomes irrevocable, you can protect the assets. You can protect it for your beneficiaries, and in some regards, you could protect it from your beneficiaries, depending upon what your individual concerns might be.
Yeah, yeah. It's really, the more people learn about it, the more exciting they would regard this as a tool for their future. I mean, some people get excited talking about retirement in terms of, planning their budget, thinking about what will their 401k produce an income for them over the next 30 years. Um, but this conversation, if people know what's at stake, I mean, it's far more exciting to plan your security and your safety and to know that you've covered those things that may not all happen, but there's a good chance in this world with medical technology and whatnot being around, people linger and people stay, and that they have this ability to give some quality of life to people who years ago it would have simply been an event and heart attack, for example, whatnot, maybe a short period of hospitalization, and then that's it. The world has changed, and now it's as important to plan for these things that are really Plan B discussions. But Plan B, it seems, comes into place in some cases, more commonly than A. These Plan B discussions, and to know that you have this wonderful plan in place that gives you assurance that the things that are most important to you while alive and when dead are taken care of. But I will say that there is some cost to operation the trust, and not significant. But I wanted to touch on this, John, because I know this is one of our questions that we had identified that people ask us online as well as in offices. What about the costs of maintenance in terms of an attorney? Do we have to continually go back to the lawyer to have things added and changed? And when we buy and sell things, and this is a little bit different from our conversation previously, in which we talked about some of the costs or the ease with which you can operate as a trustee. If you create a trust, we'll assume you're acting as the trustee. You're the settlor, the person who created it, and so you put things in it while you're alive, as we discussed. And we can simplify that process of interacting with third parties. But I think in order to fully cover that, we should take a few minutes here, John, and talk about any additional costs there might be if you decide that you want trusts in place. Let's dispel that concern that is still in the minds of some.
Yes, similar to you said about the taxes at funding, there's no additional charges per asset, per value of asset that comes with creating a trust. One of the great things about being here at Cordell, and if you go look at our website, you'll know because it'll tell you exactly how much you'll spend up front to create a trust, right? So that's the first cost. And when we do that, we do what we call a design meeting, where we sit down and walk through all those what ifs. And by doing that, and by writing a robust plan, we're already reducing by a large factor the chances that you're going to have to come back and change something, right? If you do a quick plan, you don't think through it thoroughly, the chances you're going to have to change something go way up, right? But the more successors we put in place, the more thought we put towards what would happen and could happen, the better chance your plan survives. Now, if you do need to make changes, if they're simple ones that can be pretty cost effective, just changing out some trustees or who you've named in certain circumstances. But as far as maintaining it during your life, as long as it's well written, your funding is going to be completely on you and is not going to have a cost. And you most likely won't need to come back to us, and there's no reporting requirements. Like I said, this gets reported to the IRS on your taxes as your own property, even when it's in the trust. Now, if we're comparing it to a will, there is a little cost on the back end once it becomes irrevocable. That's because now it's become a new entity, right? We said before your Social Security number is what's reported to the IRS in relation to the trust. Well, once you've passed away, that Social Security number is no longer valid. And so they've got to get what we call a tax ID number, and then that's got a new identification number with the IRS, and they're going to start expecting annual returns. So, you just think about it as if you've created this separate entity that has its own responsibilities, accountings, annual returns, maybe getting some advice on administering it. All that has costs, but in my experience, it way less than you would if you were in a probate experience.
Yeah, yeah, and I think that people should know that if you think through, what you want your general overall plan to be, meaning the basic structure, when you want money paid out, and how you want it paid out to your loved ones. We'll assume after you've passed that part of the plan, then those generally don't change. I mean, those ideas, some people will say, I want money distributed immediately to everyone. That's not something that I advocate. And I often, suggest to clients, I make the case for an alternative way to do it. But for clients who choose to do it that way, that's probably not going to change. That's their position. So when you think about changes to a trust, let's say you make it when you're create your trust when you're 60 years old, and you want that trust to be in place for what you're confident will be the next, say, 40 years of your life. What are the chances that you'll have to come back for any structural change, meaning change as to something other than just names? I think that's not likely. Is it possible? Yes. And the good news is when you do come back to make those changes, we in this world, everyone has things stored digitally. Our firm stores things digitally. We're very high tech. We're early adopters of new technology, which means that the advantage is that you call your lawyer, you say, I want to make this change. Well, they can make that change pretty efficiently, as you were mentioning, John, and the cost is very little. And in some cases, if they're like Cordell and Cordell, that costs maybe nothing. Meaning, if there's simply a name change, like say that you decided for some reason to exclude one of your children that you'd previously included, or that you decide to add someone and remove someone else, then that's very easy for us to do. So we like to encourage our clients to circle back with us once a year or so, some more often than that by their own choice. But we encourage people to circle back once a year, have a visit. That visit, I think, is no charge unless it's changed recently. John, we're still at no charge for that annual visit.
All initial consults are going to be no charge, and so that's what that would be considered.
Okay. So we would encourage you to do that. You don't have to, but why not? And then if there's a change that you want to make, then depending on the change, it could be a change where you are charged. But the good news is there's no reason for it to be a major renovation of your trust unless, in fact, you've decided that you want to do a major renovation to your trust. But most people don't do that. They know who they love, they know who they care about, they know their priorities. Sometimes names move around a little bit, but the fundamentals, that structure I referred to, usually that doesn't change. But the good news is, whatever you want can be done, and it can be done pretty efficiently and a lot more efficiently in the 21st century than in the 20th century.
Oh, definitely, with carbon copies and all the way that when I first
Oh,
started in
God.
this, we were typing these up on carbon paper, and
Oh, my gosh.
yeah, right. But yeah, I do get these phone calls often. Hey, John, this happened, and I will tell you that the majority of the time it doesn't require a change. The way we write these documents about, instead of naming specific people, using groups like children and descendants, language you'll see in there that's flexible
That's a good point.
in and of itself. Identifying marriages, right? That's a phone call I probably get once a week. Hey, my daughter just got married. She used my last name in the trust. She's got a new one. Do I need to redo everything? No. Anybody that's going to be involved with the trust is going to know that that's your daughter. We named him out at the beginning. These little changes don't even necessarily need to be made, but we're happy to answer that question.
You're making a very good point. If our viewers just think about it for a minute, you can write things. It just makes sense for us to write things so that, if you want to treat your grandchildren equally, and maybe you won't even have grandchildren at the time you create this, but you can use language that accommodates the expected comings and goings and changes associated with life in action. So those are things where typically, the vast majority of times, those should not require a change. But are there changes where you do have to move things around in the document? Yeah, that could happen. But I hope that we've allayed the concern that this is going to become, this money pit that you invest in. The whole idea is you want to see well, I can say this more easily when I'm talking to clients of our divorce group, is that they definitely want to see their divorce lawyers as little as possible. Estate planning is a little like happy law in that, often we're talking about positive, exciting things. We're making plans. And on those occasions, we're happy to see our clients come, and clients often want to touch base once a year. And especially when they can do that without charge. And that's kind of something unusual with Cordell and Cordell. But we know also that that's the best way for, if there is a change and something that needs to be addressed, the best way for us to find out is to get you in front of us and let you tell us what's going on. Otherwise, something could have happened where there was a change that should have been made and it didn't get made. So we don't want that to happen.
And sometimes this doesn't even require the formality of a meeting, right? When you meet with me, I'm going to give you my card, and it's going to have my cell phone and my office phone on there. You just pick up the line, give me a call and say, hey, John, this is what happened. Do we need to meet? I can usually dispel or confirm whether that needs to happen pretty quickly.
Yeah, exactly. Good point. So the whole idea is that we want to make this easy for clients. We want to address the things they care most about. We want to do it as economically as we can and allow this plan to not impair or intrude on their life for the balance of their years here, and allow them to go out of this world with complete confidence that they have in place the plan that they designed to best take care of the people they cared about. So estate planning is an exciting field. Those of us who do it really enjoy it. Those of you who watch this show or who know about Cordell and Cordell know that I did domestic relations exclusively for decades, and was very good at it. And Cordell and Cordell's attorneys are very good at it. but it's refreshing now to focus on something that was always in the background for me, and that's the ability to focus on an area of the law where people tend to be more happy. There are things going on that, yeah, people die and people transition as they get older, but with proper planning, those can all be events with as little sorrow or discomfort as possible. So we like what we're doing, and we hope that those of you who watch the show, and we see our numbers have been growing, and we appreciate that. We want you, by the way, to hit like and subscribe. I don't need to tell you why that's important. You hear people on YouTube, for example, saying this all the time, and the reason is because it is the way that we can get access to new people who want to hear our message and watch our show. So we appreciate the fact that you watch this show. And today we've covered 3 topics with a little spillover in other topics, which we kind of do liberally to make these as informative as possible. So we'll continue with this series in which we pick up topics and talk about those that you have shown an interest in, you, our audience, and we try to cover them in a way that's most helpful to you. So continue watching this series. We look forward to your coming back. John, thank you for your wonderful insight, as you always provide.
Thanks for having me.
So this has been an episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.